I would now like to introduce today's speaker, Ed Goodson. Ed is the managing attorney at Cunningham Legal, an estate planning and trust administration law firm with 9 offices around California. Ed is a certified specialist in estate planning, trust, and probate law. Today, he's going to discuss common estate planning mistakes for trustees and how to avoid them. So without further ado, I'd like to kick things off by welcoming Ed Goodson. Ed, over to you.
Thank you very much, Jennifer. Hello, everyone. So today's presentation is pretty straightforward. We're going to discuss the most common mistakes trustees make and how to avoid them. But first, I have to give you a little disclaimer, legal disclaimer. This is not legal advice that I'm giving. We hope this is valuable information for you, but legal advice is when we meet with you one-on-one, talk about your situation. With that being said, let's begin. Let's start by talking about the role of a trustee. What a trustee does is a trustee is a manager. They manage assets for someone else and act on their behalf with respect to those assets. So if I am a trustee for my niece and I'm managing a house for her, I act on her behalf. The most important thing to remember if you're ever a trustee is to remember the golden rule. Treat people as you would like to be treated. So if you were the beneficiary, how would you like to be treated by the trustee? That's what you need to keep in mind. Another way to word it for the trustees is act as you would want another to act on your behalf. And so that's what you really need to think about is put yourself in the position of the beneficiary. What would you want the manager of your assets to do?
Okay, so if you've joined us in the past, you know that sometimes we start with a poll, and we're going to do that this time. So we have a 2-part question poll coming. The first question is, are you currently acting as trustee for someone else? And the response options are yes and no. Go ahead and take the next 15 or so seconds to make your selection, and then we'll share the results. Okay, it looks like most of the results are coming in. Okay, we're going to go ahead and close out the poll, and it looks like most of you have said no, you're not currently acting as a trustee. So for those of you who answered yes in the first question, we're asking as part of our second poll, if you are acting as a trustee, have you consulted any of the following professionals? Go ahead and choose those options available. You'll see 4 different answers. Go ahead and make your selection, and then we'll share the results of this poll. Okay, we are close to finishing the poll. We see most of you have responded, and we can end the polling, and it says, I am not acting as a trustee, with a close, almost tied CPA, tax preparer, and then attorney. So interesting, Ed.
Very good. I'm glad to see that you're consulting tax professionals and attorneys, because I'll be talking about that later on, as each of those is big mistakes that some people make by not consulting with them. So let's move on. When you're the trustee, you're the one carrying the ball. Everybody is depending on you. Don't drop the ball. A lot of times what we find is that people get tired of being trustee and they just kind of let it slide. You can't let it slide. You're not going to make it to the end zone, and people will be hurt as a result. And if somebody's hurt and you're the trustee, you may end up paying for the harm that you cause. Trustees have a lot of potential liability. I don't know if you know this, but most attorneys won't agree to act as trustees for other people. That's because attorneys understand liability very well. You got to be careful if you're acting as trustee. You have potential liability to the beneficiaries, but also potential tax liabilities if you mess up. You don't want to mess up. Okay, so now we're going to start going through the top mistakes, beginning with not following the terms of the trust. This is a big mistake a lot of people make. You need to use the right trust documents, you need to understand the trust's terms, and you need to follow the decedent's wishes as they appear in the trust. So let's talk about those things. First, as far as using the right trust documents, sometimes it's just not very easy to find the right trust documents. You need every page of the signed trust, you need its amendments, and you need its restatements. Usually the most recently signed documents are the ones that control. And by the way, photocopies are okay. In fact, PDF, electronic copies are also okay. They're way better than nothing. So a lot of people are looking for the original of a document. Hey, if you've got any copy of the signed document, that's something that's going to be valuable. So once you've found the right trust documents, and it's usually the most recently signed ones that control, once you've found the right ones, now you have to figure out what they mean. And trusts are typically written in legalese. You need an expert attorney to interpret the trust terms at the beginning of the process, because your job as trustee is to follow the terms of the trust. And I can tell you, we've had a lot of situations where people were absolutely convinced that they understood the terms of the trust, and then a lawyer takes a look at it and understands it as meaning exactly the opposite, because sometimes legalese is pretty hard to follow. Finally, following the decedent's wishes as they appear in the trust. This happens all the time. Somebody in your family has told you, I really, really want my home to go to Marcia. And then they die and their trust doesn't give the home to Marcia. Well, what you have to do is you have to follow their wishes as they appear in the trust. You cannot take into account contrary things that they told you on their deathbed. It's illegal to do so. Now, if it's an ambiguity, sometimes with the help of an attorney and the help of the other beneficiaries, we can push things towards the wishes of the decedent, even if they didn't appear in the trust, but you absolutely should not do that alone. All right. The next mistake commonly made by trustees is not communicating well with beneficiaries. You have a duty as a trustee to keep beneficiaries informed of what you're doing. And let me just explain what this means. This means that you cannot keep secrets from them about what's going on in the trust administration. They're entitled to be kept apprised of what's happening, and they're also entitled, it's in the probate code in California law, they can ask you for information and you have to give it to them. And if you don't give it to them, they can just go to court and have you removed as trustee. It is your job to keep them informed. A lot of times, while you're busy keeping them informed, you might find that they ask you to do things that you really hadn't planned to do. Sometimes they ask you to distribute money early or give them a loan for $5,000 or whatever. There's lots of things they can ask for. I highly recommend that you listen to them, make sure you understand what they're requesting, but don't agree to anything until you've talked to your attorney, because you are bound by the terms of the trust and you're bound by other laws. You have to treat everybody equally, all of the beneficiaries equally. And a lot of times we see trustees getting tucked into things that they really shouldn't be doing. And sometimes those things are not just bad ideas and opening up to liability, but they're also illegal. So we have to be very careful. Finally, be kind and listen. And by be kind, what I mean there is when you're a trustee, you have a lot of power, but you work for those people. And so you don't really want to cross them. One of the things I see fairly frequently is mom dies and say a son lives in the house with mom the last year of her life. And now it's time to sell the house. Mom is gone. It's time for the trustee to sell the house. And I've seen some trustees not treat the son who lives there with respect and kindness. This is somebody who's going to have to find another place to live. And in California, that can be extremely difficult. And maybe they don't have money right then to pay a first and last month's rent. You got to work with them to work it out. There's a lot of things that people in times of grieving need a lot of help and kindness and somebody to listen to. And being a successful trustee involves all of those things. Hurting people's feelings, in my opinion, is one of the easiest ways to get into a lawsuit. So my experience working for years in this field is that one of the easiest ways to push your family into all kinds of trouble is to not inform certain people of the death, or to not invite somebody to the funeral. It just rubs people the wrong way and they start getting mad, and eventually it becomes a lawsuit on something. So really got to think about people's feelings a lot. When you're the trustee, hurting somebody's feelings is a bad move for you. All right. The next mistake we're talking about is commonly made is inappropriate spending and expenses. You know, in almost every case we work on, I have the trustees asking me, what can I pay for? You know, for example, maybe the trustee lives in Sacramento, but most of the trust property is in San Diego. So the trustee has to ask, well, do I fly down? Do I take my car down? How much can I reimburse myself? There are a whole bunch of things that we have to worry about. So here are some general rules. There are no hard and fast rules, but general rules. Keep expenses reasonable. Be frugal. Okay, that's the first thing. You can, if you think about it, if you were the beneficiary, you don't want to spend a whole bunch of money having the trustee pay for dinners for himself, for $100 dinners on your money. That just doesn't make sense. But on the other hand, if the trustee has to visit San Diego and has to travel for the work, having them pay something reasonable like $15 or $20 for dinner, that is much more reasonable and doable. Next thing, don't hire yourself or your family for something. So this most often comes up when we're cleaning out a house. Frequently, mom dies, the trustee needs to clean out the house before selling it, and the trustee just figures, oh, I'll pay myself and I'll pay my family members to clean out the house. Well, if you're going to do that, you have to look at the other options. The other options is you could pay somebody about $2,000 to clean out most houses, and they do it professionally and very quickly. And they even, on top of that, many of them will run the estate sale. So if you're going to pay yourself more than $2,000, that's not a good deal for the beneficiaries. Also, if you're going to take a lot of time, that doesn't make sense. Finally, you can't, as a trustee, you can pay yourself a fair amount, and that might be $50 to $100, but you can't pay yourself that kind of money for being a worker and cleaning up a place. They don't get that much. And anybody you hire, including family members, you have to follow all of California's labor laws. So it's a dicey proposition. I'd recommend not hiring yourself or your family to do that kind of work. Next, avoid optional expenses because it's not your money. There are some things that you might regularly do that aren't appropriate for you to do as a trustee. So if one of the things that you really like to do is large brunches, you like to have a large brunch every day, and you're willing to spend $50 every time you have a large brunch, don't do that when you're a trustee. Well, you can do it, but you just have to pay for it yourself. Don't ask the beneficiaries to pay for that. All right. What happens in the end is you, at the end of a trust administration, or at least annually, you have to give a report to the beneficiaries on how much you paid for different things. And when they look at the things you paid for, they have the right to say, wait, that was inappropriate. And if something is inappropriate, you're going to have to pay the money back. The better way to do it is just do things appropriately as you go on the way. All right. The next mistake commonly made is errors in trustees' compensation. So this is different. I was just talking about how much money you spend on your expenses. Now we're talking about you getting paid for your job as trustee. Now you deserve, if you're acting as trustee and you're doing a good job, you deserve to be paid. The law says if you're not doing a good job, you don't deserve to be paid. But as long as you do a good job, you deserve to be paid a reasonable amount. It is possible that your trust says something different, but that happens in less than 1% of the trusts that I've seen. So usually it's a reasonable amount. So what's a reasonable amount? Well, it depends on which county you live in. As it turns out, if you happen to live in, say, Napa County or in Los Angeles County, the courts will typically say you can pay yourself 1% of the value of the trust under management each year. Well, that's very nice, and that could be generous. On the other hand, most of California's counties say that it's nothing of the sort. They don't want to see anything to do with 1%, and they want to see your detailed hourly billing. And if you don't have the detailed hourly billing, the way they look at it is you probably aren't entitled to any payment. So you got to make sure to keep good records. And even if you are in Los Angeles or Napa counties or a county that accepts the 1% rule, if somebody contests how well you were doing, or you really need to have that hourly billing there. How much are you worth per hour? It depends. In Contra Costa County, the local rules simply say that if you work as a trustee, you're worth at least $35 an hour. So just start with that. Trustees who also who are also CPAs, they would charge more like $150 or $200 an hour. So there's a very wide range. You need to talk with your attorney about that.
Okay, everyone, it's time for our next poll question. And the question is, do you expect to act as a trustee in the future? And the response options are yes, no, or unsure. Go ahead and take the next 15 or 20 seconds to select your answer, and then we'll go ahead and share the results. Okay, great. It looks like most of you have responded. We'll just go and give you a few more seconds. All right. So we're going to share those results, and it looks like most of you have answered yes. You expect to act as a trustee in the future.
Well, bless you all for doing that. For a lot of people, it can be a really good experience in helping and getting to know members of the family, and for some people, if they make the mistakes that we're talking about today, it can be, let's say, a less good experience. So let's talk about the next mistake that people make. It's mismanaging assets. Now, this is one where I think that attorneys are not advising, many attorneys in many law firms are not thoroughly advising their clients on what is required by law and what is required by good common sense. Okay, so number one, a written financial plan is required. And my experience is that there are not many attorneys in California telling their clients that that's the case. It's in the probate code. It says so. When you act as a trustee, you are managing assets for somebody else, and the code requires you to have a financial plan for the management of those assets. One of the most important things that the code says is that you have to have a diversified portfolio. So let's talk about what happens when you don't have a written plan and you don't have diversification. So let's just say you're managing the house that you see on the screen there and all the assets that are inside the house, and maybe whoever died had a couple of bank accounts and a brokerage account. So you're managing those things, and as it turns out, the house is worth 3/4 of the total value of the estate. So as long as that house is sitting there, you're under-diversified. So something bad happens in the neighborhood, and all of a sudden, the value of that house goes down by 30 or 40%. Well, the beneficiaries have been harmed. Now, let's look at it a couple of ways. If you had a written financial plan that said, we're going to try to sell that house as quickly as possible, and that's the reasonable thing to do because you're not diversified. Unless somebody who's a beneficiary has to live there, you need to diversify by selling that house. If you have the written plan saying that you're going to try to do that, and then you are actually taking reasonable steps to do that, to diversify, even though you've suddenly lost this huge amount of money, you have not breached the trust, and you probably can't be successfully sued. But if you don't have a written plan, then they're just going to say, well, wait a minute, you should have sold the house faster. And you were managing it, and you could say, well, I was trying. Well, how do I know you were trying? You didn't have anything in writing. So it's an evidentiary thing. You just have to have a written plan, because market risks and other things that happen are going to come out of your pocketbook. All right. So what do you consider? You consider diversification, but you also need to look, when you have real property, about Proposition 13 reassessment. You need to really think about making that work well. By the way, if you're passing on the house to somebody in the family, if they're children of the decedents, they can keep mom and dad's low Proposition 13 tax rate, but only if the trustee does things right. If the trustee blows it, all of a sudden it costs the kids, reassessment is $2,000 or $3,000 a year for the rest of the time they live in that house. They're not going to like that. If you're going to sell a house, get a real estate broker. I know a lot of people think that they can sell it themselves. They could do as good a job as a broker. the law kind of assumes that you can't. The law assumes that the real estate brokers are going to come in with the best price for you overall. I certainly believe that based on my experience. And we have some clients who are real estate brokers themselves. Please, if you're in that situation, you're a real estate broker and you're a trustee, don't assume that you have the right to list the house with yourself. You actually don't, unless all of the beneficiaries sign off on it. So you don't want to do that. Now, taking too long to sell the house. This is something that happens all the time, especially when it's mom or dad who has died and now the house is vacant. What happens is a lot of time the trustee, as part of the grieving process, goes into the home and starts cleaning up the place and going through boxes and reminiscing, and maybe there's a lot of tears, and it takes a long time. I've had clients take over a year to clean out a house before selling. That is a breach of trust. That is totally inappropriate. What you need to do is you need to get all those things boxed up and put in a storage unit, and then sell the house as quickly as possible in most cases. Meanwhile, you can go to the storage unit and you can use that as the place where you reminisce and go through the boxes. But making people wait for their inheritance so that you can grieve is not appropriate. Finally, another thing that you really need to look at is that asset sales trigger taxes. So when you sell a house, there's a potential for capital gains taxes. When you sell stocks or bonds or other securities, there again, possible taxes. So you need to talk with your tax advisors and your attorneys to do this. If I had to say the one thing that I see most trustees blowing it on, it's mismanagement of assets. They don't have a written financial plan. They haven't thought things through. And I've seen many, many times where trustees just have to beg forgiveness of their nieces and nephews and wish they had done better.
So we have a question from Heather, and she's saying her mom left her the house, and she currently lives in Placerville County. Heather wants to know, does that mean Prop 13 won't be reassessed since she lives in Placerville County?
You mean Placer County?
Placer County, excuse me.
Okay, so ask me the question again. Threw me off when the...
So Heather's asking, my mom left her house to me and we live in Placer County. Does that mean Prop 13 won't be reassessed?
Okay, so it should be that she can take a house from her mom without reassessment, but it depends on exactly how the trust is written. So if Heather has a sibling who is going to get, say, half, and Heather's going to get half, it's really, really important for the trustee to consult with a good attorney before distributing the home. Because if you don't, this is exactly the place where you can accidentally have the Proposition 13 reassessment. In the end, the reassessment won't occur as long as Heather can show that she got half and then her sibling got half. But sometimes you need to get a bridge loan to make that happen. And so we could certainly help you with that. But this is exactly the kind of thing where if people don't have the right professionals helping them out, it can cost some big money. So recommend that you get an attorney to help you with that. All right, so the next mistake we often see is making premature distributions. So let me first explain what premature means in this case, is that it's very, very rare that a trustee should make a distribution prior to, say, 4 or 5 months after the death. And here's why. There's a 120-day notice period that is required by law. The basic idea is this, is that if any of the decedent's beneficiaries named in the trust have a right to see the trust and have a right to contest its terms. But the legislature doesn't want them to have an endless right, so they said it's 120 days from the date that they are sent a special notice, who the trustee is, what the terms are of the trust. That notice is also sent to all of the decedent's heirs. And by heirs, I don't mean people who are receiving from the trust, I mean people who would have received assets if there had been no trust and no will, so the intestate heirs. So for example, a trust might say that there's 3 boys and the trust might say only 2 of the boys are beneficiaries. One of them is disinherited. Well, the disinherited son also gets a copy of the trust, and he gets 120 days to contest the trust. So that means that the terms of the trust actually aren't set in stone. They're not finalized until that 120-day notice period is over. And so, especially if somebody's been disinherited, you'd really be crazy as the trustee to distribute the money, because if it ends up being contested, that money is going to come out of your pocket. So making early distributions is really, really a dangerous, dicey game, and we highly recommend against that. And I've gotten involved in many cases where people did exactly that. There was a contest, and then they got lawyers involved, and it's just an absolute nightmare. You don't want that. After the 120-day period, a lot of times people say, well, okay, I got this house I still have to sell, and I got the rental home I still have to sell, but we do have $500,000 in cash. Let's distribute the cash. And I can tell you the reality is you should do exactly the opposite. Most of the cash you should save for last. The reason is that cash can be used for anything. Cash solves all kinds of problems in the law. And also you need a reserve for potential tax audit and other liabilities. So we recommend, while you don't want to hold the cash forever, you do want to make distributions to the beneficiaries in a reasonable amount of time. But holding the cash till last is almost always good advice. And by the way, since I mentioned a reasonable amount of time, sometimes people wonder when do I have to make the distributions? If the trust doesn't say anything else, you should assume that you want to make the distributions within a year of the death occurring. If it's going to take you more than a year, you really have some explaining to do to the beneficiaries to make sure they understand why that's occurring. All right. Our second to final mistake is not hiring a tax advisor. So I saw in the earlier poll that several of you had hired tax advisors. That's great. That's good news. The trustee is responsible for a bunch of things, and very importantly, the decedent's back taxes. Okay, so let's just say that I am the trustee for my uncle's estate, and he dies, and he was predeceased by his wife. And so the last 4 or 5 years of his life, he lived alone. And even though he had pretty good income, after she was gone, he kind of just didn't want to do things that he didn't like to do anymore. And so he just decided to not pay taxes and not file any taxes for 4 or 5 years. Okay, as I take the job as trustee, it's my responsibility to make sure that all of those back taxes are paid and all of those filings from the past are done. And if I don't do that, then, I mean, what's going to happen is the IRS is going to figure it out eventually, and they're going to come after my house. So it's really important to get this right. So you take the job of trustee, you are responsible for the decedent's back taxes. Does that mean that it has to come out of your money? No, it doesn't have to come out of your money. It comes out of the trust's money. But if you ignore the issue, then it comes out of your money. So don't ignore that one. All right, next thing you're responsible for is filing income tax returns for the trust. Okay, so these are 1041s and 541s. If the trust makes more than just a few $100s a year, or if there's a sale of a large asset like a home, for sure you're going to have 1041s and 541s prepared. My recommendation is don't try this yourself, and don't go to just a normal tax preparer. My experience is that the tax preparers who have lots of gray hair are the ones you want to go to for the 1041s and 541s, because they've had clients die in the past, and so they've done a bunch of these. The 1041 form looks deceptively like a 1040, except that there's different law behind it. And so I've seen lots of mistakes from tax preparers. So it's really good to have an expert do that. And you as trustee, it's your responsibility for making sure these tax returns are done correctly. For large estates, you need to file the estate tax returns. When I say large estates, the estate tax exemption is over $11 million per person right now. So it's a very small number of estates that are paying estate taxes, but that law could change in the future, could change at any time. If there are estate taxes, you got to pay the estate taxes first. And just, you got to understand this. If you owe the IRS $100,000 in estate taxes, but you kind of ignore that and distribute the trust, the IRS, again, they will come after you. They'll come after your house. They're going to get their $100,000. You've taken the responsibility. You got to get the taxes paid. All right. And our last mistake is not working with an attorney. Trustees need expert trust and estate attorneys, and they need them from the very start. There's just too much at stake for you not to do this. Very few firms have more experience than Cunningham Legal in trust administration, that is, assisting trustees with their job. We have 9 attorneys statewide. 2 of us are certified specialists in estate trust and probate law. 2 have taken the certified specialist exam. We're waiting for results. We think that they'll be successful. 2 have LLM degrees. These are academic degrees that are higher than a JD. And one's in estate and trust law and the other's in taxation law. So we really have the kind of attorneys, the kind of expertise you would need in attorneys to help you in just about any kind of situation that could come up as a trustee. What we have found is a big problem is that people think, oh, I don't need a trustee or I don't need an attorney because when mom went to this attorney to set up the trust, we thought that the trustee said it's going to be super easy. And it is. Trust administration is super easy compared to probate. It really is. But it's not free and it's not intuitive. And having an expert consult you from the very start is really important. One of the things that we found that hampers us a little bit in our ability to serve our trustee clients is that some trustees don't want to give all the information to the attorneys. It's probably no more than 10 or 15% of our clients, but sometimes we really we feel like we have to twist their arms to find out what all of the different assets are. They just didn't want to tell us about a $1 million IRA that they're collecting for whatever reason. I don't know why. And if they don't tell us, then we can't help them on it. We can't tell them the special things you have to do with IRAs to get them stretched out over time that'll save you hundreds of thousands of dollars in money. So that is an issue that we have. So we think that trustees it's a huge mistake when trustees don't work with an attorney, but they need to work with an attorney completely. I'm going to quickly explain how that works. The attorney works for the trustee and protects the trustee. So we would provide guidance and protection to the trustee. We do not work for the other beneficiaries of the trust. We're not the family attorneys. We're the attorneys for the trustee, but you get to use the trust's assets to pay for us, okay? And so you get to use the trust's assets to pay for an attorney to protect you. That's a pretty good deal. I don't know why people don't want to do that. So every once in a while, we get involved with cases only once somebody is sued. And if they had consulted us in the beginning, they never would have gone down this path. All right, so in summary, not responding to beneficiaries can be a breach of trust. Don't get sued. You got to remain engaged. All right. So if you're a trustee and you're feeling like, oh, that's the beneficiary calling me again, I'm not going to answer the phone. That is a really, really bad sign. You need to remain engaged or you need to resign as trustee. But even resigning as trustee, you need to come to an attorney first before you resign, because chances are you have a bunch of reports you need to do for the beneficiaries. And if you resign, you still have those obligations. It's better to do the reports as you're resigning. Assuming you're going to stick with the job, don't drop the ball. Remain responsive to beneficiaries. Remain responsive to your tax preparer. There are deadlines. You don't want to miss those deadlines. Remain responsive to your trust attorney. We've had situations where we call our clients and we don't hear from them for a couple of months, and we get very, very worried for them, because if that happens, that means, if it happens to us, it means they're probably not being responsive to the beneficiaries, and that's going down a really bad path. That's a sign of a trust administration that's going sour, and the trustee is going to get in big trouble. So Remember, people are depending on you. Don't drop the ball.
Okay, so before we move on to the Q&A, and we got a lot of great questions, so we do want to answer all of them. I did want to mention that as attendees of this webinar, you'll qualify for a free phone consultation with one of our attorneys. Just go ahead and reach out to us at team@cunninghamlegal.com or give us a call at 855-250-9988 to schedule or just for general questions. Okay, with that, we're going to answer some of your questions submitted during today's presentation. And as a reminder, you can still submit questions through the questions pane in your attendee panel or through the chat icon. Okay, so I want to start with this one. Deborah is saying she's not a trustee yet. Her parents used our services to form a trust, and it was filed in California, but they moved out of state. How does this work? Should we work with attorneys in California or the state they moved to?
All right, well, that's a great question. So first, if you came to Cunningham Legal for your estate planning, our estate planning packages, our trusts are designed to work in every state. So that's the good news. They are based on California law. However, we have plenty of clients, especially since we have offices near the state of Nevada and Arizona. We have plenty of clients who move to those two states all the time. And here's how I would divide it. If the person who did the estate plan moved to the state of Arizona with one of our trusts, and the trustee lives in Arizona, then the trustee needs an Arizona attorney. However, if the trustee is in California, the trustee needs a California attorney. If, on the other hand, you have a situation where the parents got their estate plan in California and they didn't move and they chose somebody in Colorado as their trustee, we would recommend that you get a California trustee. We would be glad to help you. We help trustees from all over the country with California issues all the time. On occasion, we involve trust attorneys in the states where the trustee is located. It's kind of two states. Let me just quickly explain what's going on here is that, like family law, like divorce law, probate law and trust law is on a state-by-state basis. There are a lot of similarities between the states, but there are some differences. And the usual rule is that the state law that applies is the law of the residence of the trustee. However, when you have a bunch of real estate and other property in a particular state, there's big advantages of having counsel in that state also.
Okay, great. TJ is asking, where can you go to find the final version of the trust?
All right, so that's a great question. Where can you go to get the final version of the trust? There is no repository for trusts in California, and as far as I know, in any other state. There are some companies that provide that service online, but they're not widely used. So what we typically see is when we do estate planning, and I think that a lot of other attorneys in California follow the same practice, we send our clients out with the original of the trust and original of the estate planning documents. They walk out of here with a binder with their signed originals. But before they leave, we scan all of the documents into our computer files so that we have a PDF copy of all of the signed documents. And as I mentioned at the beginning, is that the PDF or a copy is as good as original if the original can't be found. So what we hope is that the law office used will have a copy of the trust. Now, one of the things that I see fairly commonly on the listservs and other online forums that I'm with other estate planning attorneys is somebody will say, Mr. Bennett of Placerville, California has died, and we know that he got his estate plan done, he got a trust done because his home is in a trust, but we don't know which attorney. Do any of you have the files? And what will happen is the attorneys will look through their files and they will see if they have that. We had that happen recently. I mentioned Placerville because we had, after an attorney had died, we had taken over her files, and she happened to practice in Placerville. And as a result of this notice, we found that we did have the missing file. We had the trust. So the best way to find a trust, if you can't find it, is to go talk to a trust and estate attorney, and then they can contact their peers and do their best to find it.
Okay, so we received two similar questions. So I'm going to ask this one first. Jessica is asking, well, she's a newly appointed trustee, and she usually does her own taxes online. Can she do the same for the estate?
It might be possible, and I would recommend against doing your own taxes for an estate. There are a lot of different rules. So we're talking about income taxes, I assume, and capital gains taxes. And I would really recommend that you not do that. I have been practicing estate and trust law since 2001, and exclusively no other area of law. And I've dealt with a lot of cases and the 1041s and 541s. I do my own taxes at home, and I would never do my own taxes for a trust if I were a trustee. That's just too hard and too different.
And one of the other questions was, what about H&R Block?
You know what, as far as this H&R Block in particular, I don't know how well trained those people will be. I can tell you that I would feel comfortable with just about any EA, enrolled agent, that I had found. So I don't know if H&R Block has enrolled agents. Enrolled agents are people who are licensed by the IRS to provide tax prep services. So I would recommend a CPA or an EA, an enrolled agent. And I suspect that H&R Block has some enrolled agents.
Okay. The next question is from Leslie. Can a non-US citizen be a trustee? And if not, why not?
All right, let me think about this. A non-US citizen can be a trustee, but only if they are co-trustee with a US citizen. Okay, so the general rule is that if it's a non-US citizen who is a trustee, it becomes a foreign trust, and a whole bunch of complex laws apply, and especially tax laws. I have to say I haven't worked with foreign trusts much, so I couldn't tell you what those are, but I can tell you that the attorneys in this area of work go to great lengths to avoid having trusts accidentally become foreign trusts. So we do have a tax expert with an LLM in our firm, and I'm sure that he would know the answer to this. But the general rule is that if you are not on US soil, even if you are an American, you probably shouldn't be acting as trustee. And it's just very difficult to do. Even with all the communication systems we have now, it just becomes very difficult. But the more important rule is that if you are not a US citizen, doesn't matter where you are, you shouldn't be acting as trustee alone unless you've talked with a tax advisor first to make sure that it's okay.
Okay, so the next question is from James. Is the written financial plan for the estate something that can be put together before the trustee dies? Or is this something that the trustee puts together afterward when they are liquidating the estate?
Well, I really like the idea of doing it beforehand. What I would say is that when I'm helping a new trustee, if they have instructions or a guidelines or something from the decedents saying something along the lines of, here's all that we owned and here's what we had in mind. And I love that because then we don't have to look for the assets. It is hard to find assets. On the other hand, I don't want those things to be binding on the trustee. You should make them as your suggestions. Don't put them in your trust. Put them, in a separate letter saying, here's what we had in mind, because circumstances changes. Let's get this right. Circumstances change. Laws change. A lot of things can happen, and it's hard none of us can really tell the future. So giving them guidelines of what you had in mind is a great idea. But as for the rule, the trustees are required to do their own written financial plan. I hope they're going to do it with the help of a financial planner. And they're required to update it in a reasonable amount of time. And so I would always say they need to update it at least once a year. And so the rule of the game is you have to have a current financial plan. It has to be reasonable at the time you created it, and you have to be actually implementing the plan. And if all three of those things are true, then even if the markets go down, the trustee is protected from liability.
Okay, we have time for a few more questions. This next one comes from Mina. My father passed away 10 years ago, and my mom is not well educated, so I'm the trustee of my parents' trust. Am I obligated to give an annual report since she is the sole beneficiary of my father's trust?
Yeah, it's a great question. And the answer is this, is you are obligated to give your mother an annual report unless she waives that right. And she would have to put in writing, I don't want an annual report. There are many people who are taking care of their moms in situations like this, where mom doesn't have legal capacity and couldn't sign a waiver and wouldn't understand a report anyway. I would recommend in all of these situations, including Nina's situation,
Mina,
is
yeah.
that she do the report to the other beneficiaries, the people like her who will receive mom's assets after mom dies, because they are they don't legally have a right to this information right now, but the day after your mom eventually dies, they can ask for a report and a complete accounting of all that you did as trustee for all those years before she died. And so it's much better to keep them informed as we go. And it's even if you're doing all the work, and bless you for doing that. And it's really hard to be a caretaker. Do all that work, but keep the family informed as much as you can. And those reports, if your mom's okay with it, give it to your mom and to the family members.
Okay, so we've received a lot more questions, but unfortunately we're running low on time and we do want to be mindful of everyone else's time. So with that, thank you, Ed, and thank you everyone for attending today's webinar, Top Mistakes Trustees Make and How to Avoid Them. If you have any other questions, feel free to email us at team@CunninghamLegal.com. And for those of you who submitted questions and we didn't get a chance to answer, we'll be sure to follow up with you afterwards. And you'll also receive a follow-up email within a few days with a link to view today's presentation.